Bismillahirrahmanirrahim. Assalamu alaikum, dear students. Hope all of you will be doing well at your respective places. In our today's lecture, which in which we will discuss contract and its kind. It is a basic chapter in both business law and corporate law. Both students will study it, and normally all of us know that all of our social, political and economic transactions are based on contracts, and there are two or more parties to any contract or legal agreement. In this lecture we will thoroughly discuss what is contract, what is its importance in law, what is its definition, and how it is different from agreement. Now, what are the learning objectives, learning and development objectives, dear students? What is contract and agreement? The difference between the two terms will be clear to you. Definitions and meanings of the legal terms. What are the differences between the two terms? That will be clear to you after going to this lecture. Importance from business and social perspective. How our social and business transactions are based on contracts and legal agreements, and what are its practical applications for us, and then how the contracts and legal agreement have a far-flung influence on our social, political and economic life as human civilization. Now, coming to the definition of the term contract. Any agreement or promise enforceable at law is called contract, and it is said by Pollack, who is a jurist. Jurist is a person who is expert in the field of law, and he knows how laws are made, the why questions of law, why laws are made, what are their importance, and how they influence our life in social, political and economic ways. Normally you see that law is made by the parliament of a country, and once those laws are made, it is influenced by the executive, and it is explained by the judiciary, again jurists, the advocates, solicitors. So normally you see a lot of parliamentarians who belong to the law profession. People who are in judiciary, all of them are from law, while in executive you see a lot of people from law profession. So law is very important, and then contracts are very important, because all promises between the people are converted into legal agreements and contracts, and their rights and duties are again ascertained from the contract. That what are the rights of one party and the other party. If there arises any differences, then again we go back to the contract. As we see that there are different types of contract. The 1973 Constitution is a contract between the state, the federal government and the units. from which Pakistan is made, like Punjab, KPK, Balochistan, Sindh, and now Gilgit, Baltistan. All these are the 5 units of the federal state. In 1973 constitutionally clearly defines the powers and limitations of different organs of state, that is judiciary, that is executive, and that is parliament. Now in business terms, what is contract? Contract is any promise made by one person and the other person accept any offer made by one person and the other person accept that offer, and there take place a legal agreement between the two parties. For example, A sells his car on 8 lakhs to B, that is offer or proposal, and now if B accepts that, then it is a legal agreement binding on both the parties. In contract, a contract is an agreement creating and defining obligations between the parties. Samant, again a very famous English jurists, because in Pakistan most of our laws have been driven from the 1835 India Act, because Britishers rule subcontinent for almost 100 years. In the Pakistan took 1935 India Act with certain amendments as Constitution of Pakistan. Pakistan made its first constitution in 1956. The contract law, the agreement law, all of the are you can find in 1935 Act. For example, the Contract Act is first made in India, in United India, by the British government in 1872, and Pakistan took that in 1947, while made some changes, but it is actually there, while the Partnership Act was made in 1932, the Sales of Goods Act 1933. All these are examples of different kinds of business agreements and contracts between the parties, between the business organization, individuals, and even between the business organization in one country and another country. So till this point we know that all legal agreements which creates rights and obligation between the parties and can be enforced in court of law, the land law accepts that contract as a legal contract between the parties and can be enforced to court of law. That is called what? Contract or a legal agreement. Now what is agreement then? What is the difference between agreement and contract? First we will discuss agreement. Every promise or set of promises forming the consideration for each other is an agreement. Consideration is the thing of interest. For example, in this example, C offers to sell his car to B for 8 lakh of rupees, dollars, or whatever. Now in this example, the consideration is what? For C, the consideration is the money, 8 lakh, and for B, the consideration is car. Again, a thing which has value for B. In the agreement or the exchange of value and goods between the parties is called a economic transaction, and in legal term it is called a legal agreement because it creates what? Rights and duties, rights and obligations on both parties. B accepts the offer, it becomes a promise. If B accept it, then it becomes a legal agreement, and then C can enforce it through court of law because there is nothing in this contract and in this legal agreement which is against the Pakistani laws. Car is a legal thing. If its papers is legal ownership and title belongs to C, while B has 8 lakh of rupees, he earned them. That is again money come from a legal source. Now they can do a economic transaction, and that transaction will be called a contract binding on two. Both of them can perform their part of the contract to complete the economic transaction and to complete the legal obligations of the contract which they have made. So any agreement has promise or proposal. This is promise and proposal on the part of A, in 8 lakh of rupees is consideration. Now enforceability by law means that any legal agreement must, any contract must be enforceable by law. First it will be a legal agreement, as it should have promise and proposal, is both the components should be there in the agreement, while it should be enforced in court of law. An agreement is enforceable by law if it creates legal obligations between the parties which the law describes is legal obligations or rights and duties between the parties of the contract. For example, in the previous example we see that C offers to sell a car to B for 8 lakhs. That is proposal, but if B accepts, then it is a legal agreement, and that creates legal obligations on both the parties, or it is a legal contract. It creates legal obligations in both the parties, and both parties should perform their part of the legal obligation to complete the contract. I hope students you understand it. Now it should have the first component. Any contract must have, it should be a legal agreement, and then it should be enforced to court of law. Court of law, any legal agreement will be only enforced in court of law if the transaction between them is legal according to the laws of specific country. For example, in Pakistan you cannot purchase marijuana, which is a narcotics, but you can purchase that in Holland because the Netherlands laws allow buying and selling of narcotics in certain amounts to the customers, while in Pakistan you cannot purchase liquor. But in India or in some Western countries you can easily buy and sell because it's legal according to their law. Now what are kinds of agreements? As we say that agreement should be a legal agreement, so what kind of agreement is a legal agreement and what kind of agreement is not a legal agreement? So there are two kinds of agreements. One is social and the other is legal. Now if let's say in your students, all the students says to each other that whoever tops in this semester, he will offer cup of tea and samosa to the whole class. Now it's a social agreement between whoever stood first in this semester and the rest of the students. Now if let's say Ahmed tops the class and then he doesn't perform his promise, that is to give tea and samosa party to the rest of the class. You cannot compel Ahmed on his promise, because whatever was the promise, that was based on a social agreement. If somebody asks you for a dinner and you doesn't go to the dinner, he cannot sue you for damages, that he didn't come to my dinner and he has now to pay damages, because it's a social agreement. He may or he may not come, but you cannot compel him in court of law. Law does not give legal status to social agreements, but morality gives a value to social agreements as well. If Ahmed promised, then he should abide by his promises, because these moral agreements are again the foundations of legal agreements. Any society is, if it's good on moral values, its values are good, then there are very few examples of breachment of contracts and legal agreements between the parties in those societies. But if social fabric and social values are weak among individuals or of any specific society, then you see a lot of litigation itself, जिसे उर्दू में मुकदमाबाजी कहते हैं. Litigation is an index of a society where there are which is not harmonious, which has less value oriented. Such things can be inferred by the number of cases registered there and things like that. While legal agreements are those agreements which create right and duties among the parties, which are safeguarded by the law of the country. For example, I have a shop and I want to give it to someone on rent. Now I am the owner, or whoever gets that shop, he is on rent. So there are two parties, me, the owner, and the other person who will be on rent. Now there will be a legal agreement between me and that shopkeeper, and it will be on stamp paper, and whatever the terms and conditions are between me and you, for how much time he can occupy this, and what will be the rent, and what will be the annual increase, and what changes he can do in the shop, what he cannot do, and if he improve the condition, he can charge me or he cannot charge me. All those things will be there, and what will be the annual increase in the rent. So these things are clearly written in the agreement on stamp paper, and there are witnesses, and it is again registered in the court. So whenever arises any differences between me as owner of the shop and that shopkeeper, we will go back to the basic agreement, the basic contract, legal contract. But if we are unable to decide our problems mutually, then we will go to the court, and the court will decide between us as per whatever we have decided in the legal agreement, or which we also called a contract. Okay, this is for today's lecture, boys and girls. Hope you understand it. Go to your books in this lecture. In tomorrow we will take a live class on MS Teams, and your questions will be fully welcomed, and it will really generate a good discussion in the class. Okay, see you in the class. Khuda Hafiz.